Hi, welcome to Take from Caesar. My name is David Merlin. We're going to look briefly at a case. As you see, the United States District Court, Western District of Pennsylvania, is the executive action taken by the President to extend privileges, quasi-citizenship to illegal aliens unconstitutional. This court found that it was unconstitutional. And we're going to look at this decision. As you see, it was filed December 16th, 2014. It hasn't received a lot of fanfare, and it's likely the government's going to appeal this. I haven't been keeping track of that. It's the middle of January now, so this is a case that's a month old. United States of America versus Leonardo Juarez Escobar. Memorandum opinion and order of court regarding the applicability of President so-and-so's November 20th, 2014 executive action on immigration to this defendant. Does it apply to this defendant? But he's also going to rule as to whether or not it's within or without the official authority of the office of the President of the United States. Now, I have marked a couple of places in this where I'm going to read. I'm not going to read the entire decision. XXX, find next, and I end up on page 3, as you see. On April 17th, 2014, defendant was stopped by a New Sewickley Township police officer after he drove his vehicle around a traffic stop. The officer noticed open beer cans in the back seat of the vehicle and observed that defendant might be intoxicated. Henry Gomez, a minor, was also present in the vehicle. Defendant failed field sobriety test and submitted to a blood test at Heritage Valley Medical Center, Beaver. His blood alcohol level was 0.18, which is above Pennsylvania's legal limit of alcohol of 0.08 while operating a motor vehicle. Defendant was released pending the filing of a criminal complaint. As a result of this encounter, defendant was charged with two counts of driving under the influence of drugs or alcohol, corruption of minors, selling or furnishing liquor to a minor, and driving without a license. The details as to how you get cited for two of those when there's like 4 different charges, I have no idea. We're going to take up the reading of this opinion. You see at the bottom of page 6. Request for legal briefing by this court. On November 24th, 2014, in light of the recently announced executive action, the court requested counsel for the government and for the defendant to brief the following issues on or about December 5th, 2014. So he wanted briefs from the government about what they were trying to do by December 5th, and it sounds to me he already knew what he wanted to do. He thought this executive action was beyond the president's authority. Top of page 7, please brief this for me. Does the executive action announced by the president November 20th, 2014 apply to the defendant? A, if yes, please provide the factual basis and legal reasoning. B, if no, please provide the factual basis and legal reasoning. But number 2, are there any constitutional and or statutory considerations that this court needs to address as to this defendant? If so, what are those constitutional and or statutory considerations, and how should the court resolve these issues? The court also invited any interested amicus or friend of the court to submit briefs by the same date. Any party could file a response thereto on or before noon, December 11th, 2014. The government, in its 4-page response thereto, extended contended that the executive action is inapplicable to criminal prosecutions under 8 U.S.C. 1326A, and argued that the executive action solely relates to civil immigration enforcement status. Defense counsel indicated that, as to this defendant, the executive action created an additional avenue of deferred action that will be available for undocumented parents of United States citizens or permanent resident children. This is a rub you'll see mentioned later. Does it protect criminals, or does it protect just parents? There's a split there, because this illegal alien had children in the United States. In addition, defense counsel noted that the United States Citizenship and Immigration Status has announced that certain citizens of Honduras living in the United States are eligible to extend their temporary protected status so as to protect them from turmoil facing the citizens of that nation. You see footnote 4. As of this writing, it is still unknown whether the defendant is the father or stepfather of a United States citizen or permanent resident. In addition, as defense counsel points out in his brief, the parental form of deferred action, as described by the president in his executive action, will not be available for at least 180 days. However, depending on the length of sentence imposed by this court and or the options that defendant may choose given the status of his criminal case, which will be discussed, the 180 days may elapse before defendant appears before an immigration judge in a civil removal proceeding. 3. Is the president's executive action on immigration constitutional or unconstitutional? This is what this is the reason you paid the price of admission right here. Judges do this for a living, and they're going to get into all of the relevant provisions of law, constitutional provisions, and weigh the authority of the president against or under established tenets of law, constitutional constraints on different offices within the government or different branches. And I wouldn't like to be a judge. This is very intense reading, and I don't expect really the average Joe or Jane to be able to go out there and pick up a court case and read it. You look at all these numbers and it makes the eyes roll back in your head. But this is the reason I take an opportunity like this to go through a case and touch on a couple of salient points that I want to bring out personally. If you want to read the whole case, you're certainly welcome to. But to have someone read along and skip over the cites so that you can hear the context of the case without having to weed it all out for yourself. When I read a case, I'm able to jump through the writing to the meat of the issue and ignore the numbers and cases cited for the most part when I read a case to discern the context and ramifications of the decision. Separation of powers under the Constitution. Under our system of government in the United States, Congress enacts laws, and the President, acting at times through agencies, faithfully executes them. Article 2, Section 3, the Take Care Clause, also known as the Faithful Execution Clause. In NLRB versus Canning, the United States Supreme Court reiterated that the separation of powers can serve to safeguard individual liberty, and that it is the duty of the Judicial Department in a separation of powers case, as in any other, to say what the law is. This doesn't apply to tax law. Every judge is as corrupt as the day is long, and they will not decide very particular statutes of the tax code. So this applies in this case, but it doesn't apply in other cases when you're going to limit the government's money that they steal. The court requested that the parties provide briefs to assist the court. That's a misspelling. This is a conversion from PDF to Word. The court requested that the parties provide briefs to assist the court in determining whether the executive action on immigration announced on November 20th, 2014 would impact the sentencing of this defendant. Specifically, this court was concerned that the executive action might have an impact on this matter, including any subsequent removal or deportation, and thereby requiring the court to ascertain whether the nature of the executive action is executive or legislative. If it was executive, the president can do this. But if it's legislative, if he's changing the law, it's beyond his authority. B, substance of the executive action. On November 20th, 2014, the president addressed the nation in a televised speech during which he outlined an executive action on immigration. The text of the speech is at this particular web address. The president stated that the immigration system is broken, in part because play by the rules but watch others flout the rules. Some play by the rules and others flout the rules, which is so hypocritical I can't describe it. The president outlined that he had taken actions to secure the borders and worked with Congress in a failed attempt to reach a legislative solution. However, he stated that lack of substantive legislation necessitated that his administration take the following actions that will help make our immigration system more fair and more just. He said, first, we'll build on our progress at the border with additional resources for our law enforcement personnel so that they can stem the flow of illegal crossings and speed the return of those who do cross over. Second, I'll make it easier and faster for high-skilled immigrants, graduates, and entrepreneurs to stay and contribute to our economy, as so many business leaders have proposed. Third, we'll take steps to deal responsibly with the millions of undocumented immigrants who already live in our country. As to the third action, which may affect defendant, the president stated that he would prioritize deportations on actual threats to our society. The president also announced the following deal. If you've been in America for more than 5 years, if you have children who are American citizens or legal residents, if you register, pass a criminal background check, and you're willing to pay your fair share of taxes, you'll be able to apply to stay in this country temporarily without fear of deportation. You can come out of the shadows and get right with the law. That's what this deal is. Thus, in essence, the President's November 20, 2014 executive action announced two different enforcement policies. One, a policy that expanded the granting of deferred action status to certain categories of undocumented immigrants. And two, a policy that updated the removal and deportation priorities for certain categories of undocumented immigrants. 1. Deferred action. The first policy on deferred action provides that individuals who fall within each of those proscribed or prohibited categories would not be deported by President Obama's administration. Oh, I said it. Sorry, the President's administration. All we're saying is that we're not going to deport you. According to the President, his executive action does not grant citizenship, the right to permanent residence, or entitlement to benefits of citizenship, and does not apply to individuals who, 1, have recently come to the United States, or 2, those who might come in the future. However, the executive action does create substantive rights, including legal work authorization documentation, access to Social Security numbers, and other tangible benefits. This executive action has been implemented through memoranda by the Secretary of the Department of Homeland Security in a memorandum called Exercising Prosecutorial Discretion with Respect to Individuals Who Came to the United States as Children and with respect to certain individuals who are the parents of U.S. citizens or permanent residents. Under the executive action and applicable administrative guidance, an undocumented immigrant would be eligible for the deferred action if he or she applied for deferred action if he or she, 1, is not an enforcement priority under Department of Homeland Security policy, 2, has continuously resided in the United States since before January 1st, 2010, 3, is physically present in the United States both when Homeland Security announces its program and at the time of application for the deferred action, 4, has a child who is a citizen, a U.S. citizen or lawful permanent resident, and presents no other factors that, in exercise of discretion, make the grant of deferred action inappropriate, citing that memorandum, which we can skip. Number 2, removal deportation priorities. The Department of Homeland Security has issued a memorandum to reflect the priorities of deportation referenced in the President's executive action, which will become effective January 5th, 2015. Individuals who may otherwise qualify for deferred deportation under the executive action will not be permitted to apply for deferred action if they are classified in one of 3 categories of individuals who will be prioritized for deportation. The Secretary of Homeland Security provided that the civil immigration enforcement priorities, apprehension and removal, will be as follows. Priority 1, threats to national security, border security, and public safety, which includes those who are engaged in or suspected of terrorism or espionage, or apprehended attempting to enter the United States, if they have been convicted of an offense involving gangs, if they have been convicted of a felony other than a state or local offense for which an essential element was the alien's immigration status, and have been convicted of an aggravated felony. Priority 2, misdemeanants and new immigration violators, which includes those who have been convicted of 3 or more misdemeanor offenses arising out of 3 separate incidences other than minor traffic offenses or state or local offenses involving their immigration status, convicted of a significant misdemeanor, apprehended after unlawfully entering or re-entering the United States and cannot establish to the satisfaction of an immigration officer that they have been physically present in the United States continuously since January 1st of 2014, and found to have significantly abused the visa or visa waiver programs, and 3, other immigration violations, which includes those who have been issued a final order of removal on or after January 1st, 2014. The memorandum sets forth that individuals in all 3 of these priority groups should be removed from the United States unless they qualify for asylum or other forms of relief. Further, undocumented immigrants who are not within these categories may be removed, provided, in the judgment of an ICE field office director, removing such an alien would serve an important federal interest. All decisions regarding deportation are to be based on the totality of the circumstances. C. Differentiation between executive action and executive order. This is interesting. Authority for executive actions and orders must be based upon, this is actions and orders, must be based upon the Constitution, statutes or treaties, or 3, the President's inherent authority to ensure that the laws are faithfully executed. How's he going to do that? Laws don't count. These powers are limited, even during times of national crisis. Although the framers of the Constitution and Congress have not defined the instruments of presidential authority, including executive orders and executive actions, these terms are not interchangeable. The House Government Operations Committee has provided the following description of an executive order. Executive orders and proclamations are directives or actions by the President, When they are founded on the authority of the President derived from the Constitution or statute, they may have the force and effect of law. In the narrower sense, executive orders are generally directed to and govern actions by government officials and agencies. They usually affect private individuals only indirectly. Executive orders are required to be published in the Federal Register, 44 U.S.C. 1505. Federal courts can review the constitutionality of executive orders. In 2 instances, federal courts have found that specific executive orders were unconstitutional. See Youngstown Sheet and Tube Company versus Sawyer, where the United States Supreme Court found that President Truman's executive order authorizing the Secretary of Commerce to control operation of the majority of the country's steel mill was unconstitutional because President Truman acted without constitutional or statutory authority. Chamber of Commerce of U.S. versus Reich. The United States Court of Appeals for the District of Columbia Circuit found a 1995 executive order issued by Clinton which prevented employers who were performing under federal contracts from hiring strikebreakers to be unlawful because it impermissibly prevented employers from hiring their chosen workers. Executive actions do not have a legal definition. Executive actions have been used by presidents to call on Congress or his administration to take action or refrain from taking action. Executive actions are not published in the Federal Register. D. The president's historic position that executive action or orders on immigration would exceed his executive authority. If this judge wasn't convinced that it was unconstitutional, he would have spared the president this expose. This judge had it out for the president, and he wanted to bring out this laundry as part of his decision. President Obama has stated that he is constrained from issuing an executive action or order on immigration because such action would exceed his executive powers as demonstrated by the following. America is a nation of laws, which means I, as the president, am obligated to enforce the law. I don't have a choice about that. That's part of my job. But I can advocate for changes in the law so that we have a country that is both respectful of the law but also continues to be a great nation of immigrants. With respect to the notion that I can just suspend deportations through executive order, that's just not the case, because there are laws on the books that Congress has passed. We've got 3 branches of government. Congress passes the law. The executive branch's job is to enforce and implement those laws, as then the judiciary has to interpret the law. There are enough laws on the books by Congress that are very clear in terms of how we have to enforce our immigration system that for me to simply, through executive order, ignore those congressional mandates would not conform with my appropriate role as president. Do tell. Sometimes when I talk to immigration advocates, they wish I could just bypass Congress and change the law myself. But that's not how a democracy works. What we really need to do is to keep up the fight to pass genuine, comprehensive reform. This is the ultimate solution to this problem. That's what I'm committed to doing. Now, I swore an oath to uphold the laws on the books. Now, I know some people want me to bypass Congress and change the laws on my own. Believe me, the idea of doing things on my own is very tempting, I promise you, not just on immigration reform. But that's not how our system works. That's not how our democracy functions. That's not how our Constitution is written. It happens to be a representative republic and not a democracy. Hello, constitutional scholar and professor, Horsepucky. The president's statements evidence that prior to November 20, 2014, he viewed an executive action similar to the one issued as beyond his executive authority. The president has also evidenced that systematic categories of delayed deportations would be impractical and unfair. There are those in the immigrants' rights community who have argued passionately that we should simply provide those who are here illegally with legal status, or at least ignore the laws on the books and put an end to deportation until we have better laws. I believe such an indiscriminate approach would be both unwise and unfair. It would suggest to those thinking about coming here illegally that there will be no repercussions for such a decision, and this could lead to a surge in more illegal immigration. And it would also ignore the millions of people around the world who are waiting in line to come here legally. Ultimately, our nation, like all nations, has the right and obligation to control its borders and set laws for residency and citizenship. And no matter how decent they are, no matter their reasons, the 11 million who broke these laws should be held accountable. While the President's historic statements are not dispositive of the constitutionality of his executive action on immigration, they cause this court pause. The court must examine whether his executive action is within the President's executive authority and whether it would unjustly and unequally impact this defendant in light of this court's obligation to avoid sentencing disparities among defendants with similar records who have been found guilty of similar conduct. 18 U.S.C. 3553. A very important statute at sentencing. This is the criteria that a judge is required to consider. E. The administration's justification for the executive action. 1. Opinion of the Office of Legal Counsel. On November 19, 2014, the Office of Legal Counsel of the United States Department of Justice issued a memorandum of opinion for the Secretary of Homeland Security and the Counsel to the President, which addressed the following. 1. Whether, in light of Homeland Security's limited resources to remove undocumented immigrants, it would be permissible for the department to implement a policy prioritizing the removal of certain categories of aliens over others. And 2, whether it would be permissible for Homeland Security to extend deferred action to certain aliens who are the parents of children who are present in the United States. The Office of Legal Counsel advised that the then proposed executive action would be within the lawful scope of Homeland Security's discretion to enforce immigration laws because Congress has passed legislation permitting certain classes of individuals to be eligible for deferred action. Immediate family of lawful permanent residents who were killed on September 11th. Congressional legislation emphasizes uniting undocumented immigrants with lawfully present family members. Congress has never acted to disapprove or limit categorical deferred action. Congress has enacted legislation appearing to endorse deferred deportation programs. The executive action reflects considerations within the agency's expertise. The executive action is of temporary duration, and immigration officials retain discretion to screen undocumented immigrants on a case-by-case basis to determine whether their application for deferred deportation is approved, thereby avoiding the creation of a rule like entitlement to immigration relief or abdicating DHS's enforcement responsibilities for a particular class of aliens. 2. The President's justification. President contended in his televised address that his executive action is lawful and akin to actions taken by other presidents, both Republican and Democrat. The sole citation to authority in the president's speech was from the Old Testament, paraphrased as, "We shall not oppress a stranger, for we know the heart of a stranger. We were strangers once too." Oh, sure. The president has stated that his executive action was justified by congressional inaction, and 2, that his executive action is authorized by his prosecutorial discretion to defer immigration actions. Number 1, look at this. His executive action was justified by congressional inaction. If Congress won't write a law, I'll make the changes myself. Well, who governs this country? The executive branch is bound by the law. States can take action when the federal government fails to take action. But the president can't take action just because Congress has failed. Congress controls the country. It writes the laws. And that fact alone very much limits the prerogative of the executive branch. Period. They can't make executive orders that contradict law. The law is the law. The executive branch is bound to enforce it. Evans versus Gore. Just amazing. F. The executive action on immigration is unconstitutional. In determining whether the executive action is applicable to the defendant, this court must first determine whether the executive action is constitutional. The court is bound to ensure that the Constitution's structural safeguards are preserved. This role cannot be shared with other branches of government any more than the president can share his veto power or Congress can share its power to override vetoes. Hear ye, hear ye. Number 1, inaction by Congress does not make unconstitutional executive action constitutional. The president contended that although legislation is the most appropriate course of action to solve the immigration debate, his executive action was necessary because of Congress's failure to pass legislation acceptable to him in this regard. This proposition is arbitrary and does not negate the requirement that the November 20th executive action be lawfully within the president's executive authority. It is not. In the framework of our Constitution, the president's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker. The Constitution limits his functions in the lawmaking process to the recommending of laws he thinks wise and the vetoing of laws he thinks bad. Congress's lawmaking power is not subject to presidential supervision or control. Perceived or actual congressional inaction does not endow legislative power with the executive. This measurement, the amount or length of congressional inaction that must occur before the executive branch can legislate, is impossible to apply, arbitrary, and could further stymie the legislative process. Further stymie, like Harry Reid refusing to bring 300 bills passed by the House of Representatives to a vote on the floor of the Senate. That kind of stymieing of the legislative process, I wonder. The temporal limits of so-called inaction is arbitrary because of considerations such as when the clock on inaction would begin and how long inaction would have to persist before otherwise unlawful legislative executive action would become lawful. For example, would it be permissible for a president who is dissatisfied with a high tax rate on long-term capital gains as limiting economic growth to instruct the IRS to only collect taxes at a rate of 15% rather than the legislative prescribed 20% rate, or defer prosecution of any taxpayer who pays at least 15 but not the full 20 unless Congress pass a bill lowering the rate within a specified time period? Both the IRS scenario and the executive inaction at issue in this case violate the separation of powers. The president stated that the only recourse available to those members of Congress who question his wisdom or authority in this regard would be to pass a bill, and that the day I sign that bill into law, the actions I take will no longer be necessary. Presidential action may not serve as a stopgap or a bargaining chip to be used against the legislative branch. While the power of exercising the laws necessarily includes both authority and responsibility to resolve some questions left open by Congress that arise during the law's administration, it does not include unilateral implementation of legislative policies. Further, the President's belief that this executive action is within his executive authority is not dispositive because the separation of powers does not depend on the views of individual presidents, nor on whether the encroached upon branch approves of the encroachment. Likewise, Congress's alleged failure to pass legislation invalidating or limiting past executive actions or orders relating to deferred actions does not evidence that such exercises are lawful and does not constitute a grant of legislative authority. This executive action crosses the line, constitutes legislation, and effectively changes the United States immigration policy. The President may only take care that the laws be faithfully executed. He may not take any executive action that creates laws. Article 2, Section 3. Number 2, executive action goes beyond prosecutorial discretion. It is legislation. Presidents and certain members of their administrative agencies may exercise prosecutorial discretion over certain criminal matters on a case-by-case basis. Prosecutorial discretion in the context of immigration applies to a broad range of discretionary enforcement decisions, including the following: whether to issue, serve, file, or cancel a notice to appear, whom to stop, question, and arrest, whom to detain or whom to release, whether to settle, dismiss, appeal, or join in a motion on a case, and whether to grant deferred action, parole, or stay of removal instead of pursuing removal in a case. The President invoked this discretion when he stated that his executive action allowed his administration to prioritize deportation on actual threats to our society: felons, not families; criminals, not children; gang members, not a mom who's working hard to provide for her kids. Oh, it's just so heart-rending. However, the President's November 20th executive action goes beyond prosecutorial discretion because, A, it provides for a systematic and rigid process by which a broad group of individuals will be treated differently than others based upon arbitrary classifications rather than case-by-case examination, and B, it allows undocumented immigrants who fall within these broad categories to obtain substantive rights. I think it was Judge Andrew Napolitano that nailed this far in advance, and probably Michael Savage as well, who has a great talk show. First, the executive action establishes threshold eligibility criteria before undocumented immigrants can apply for their deferred action status. The Office of Legal Counsel acknowledged that this class-based program and threshold criteria was problematic, but concluded that the program does not in and of itself cross the line between executing the law and rewriting it. Despite the so-called case-by-case determination of eligibility for deferred deportation, such as passing a criminal background check, the threshold criteria will almost wholly determine eligibility. Such formulaic application of criteria, especially given the wide breadth of the program, in essence, substantially changes the statutory removal system rather than simply adapting its application to individual circumstances. Secondly, the executive action goes beyond temporarily deferring deportation for specified groups of undocumented immigrants. Secretary Johnson, in his memorandum on prosecutorial discretion, stated that deferred action is legally valid if it is on a case-by-case basis and may be determined at any time at the agency's discretion. The executive action provides for a process by which undocumented immigrants will become quasi-citizens, such that the status given to those within President the president's executive action could not be terminated at any time. Individuals who qualify under the executive action are invited to apply for deferred action status. Those individuals will be permitted to apply for work authorization documentation if they can demonstrate economic necessity, and they will temporarily cease accruing unlawful presence for the purposes of 8 U.S.C. 1182. Can't have that. The administration has based the executive action in large part on the humanitarian interest in promoting family unity. This overarching value will render any rescission of the executive action by legislation or withdrawal by another administration arguably unjust, as it would violate core American familial values to abruptly deport these individuals who are families, not felons, and have been allowed to deepen and strengthen already existing ties to their lawfully present American family members and the wider community. Conclusion. The President's unilateral legislative action violates the separation of powers provided for in the U.S. Constitution, as well as the Take Care Clause, and therefore is unconstitutional. Does it apply to this defendant? We're not looking at this for that purpose. Conclusion. This court must determine the applicability, if any, of the executive action upon this defendant. Thus, first, the court must determine whether the executive action is unconstitutional. The court holds that the executive action is unconstitutional because it violates the separation of powers and the Take Care Clause of the Constitution. If, however, the executive action is lawful, the court must determine if the executive action applies to this defendant, who does not fall within one of the three priorities requiring deportation. The court record is undeveloped as to whether the defendant falls among the newly created parent category for deferred action or has some other argument for deferred action. Thus, the court sets forth the following schedule. By certain dates, it is hereby ordered that the defendant shall file a notice and motion of his decision to proceed in one of the following manners. Either seek to withdraw his guilty plea in light of the executive action, or continue to sentencing to time served, 6 months, with a 1 year of supervised release to be served in the United States so that he may pursue his rights, if any, pursuant to the executive action or otherwise, or continue to sentencing to time served with suspended supervised release and with instruction to the United States Marshal Service to deliver defendant to ICE for deportation, no doubt. 2, the government shall file a response to defendant's motion. And 3, this order does not impinge the right to file any other request or motion. Arthur J. Schwab, dealing the President the fatal blow. Your executive action is unconstitutional. You're writing law from the Oval Office. Congress controls the country. You can't go to war without Congress. We've been doing that for years. And in this instance, the judge came down on the side of the Constitution, and it appears without even a motion in front of him. He didn't say because of a motion filed by somebody. He simply said, to decide whether or not the executive action applies to this defendant, I first have to decide whether or not it's constitutional. If it's unconstitutional, all bets are off. So, anyway, this is a right from the mouth of a judge, a district court judge, about whether or not the president can do what he did regarding immigration. My name is David Merlin. When you see court decisions come out, take a dive into the deep end. Go get that decision and read it. The second time you read a case, it'll be easier. The third time, easier than that. I've read in excess of 4,000 decisions, and it's possible. It won't happen on your first time through or your second time through, but the more you read them, the more you'll be able to flow through all of the sites and everything to get to exactly what the judge is trying to say. And understand, when you read them, It's much closer to proper grammar than you'll ever hear on the radio, especially on Fox, which offers horrid grammar all day long as a matter of habit on the talk shows and as a matter of choice during the newscasts. They're speaking headline speak, omitting the word is, the word are, A-R-E, and speaking as if they're reading headlines to you. And it sounds so stupid to me that I have to change the channel or turn them off until the talk show comes on. And even then you hear him saying, "What are you seeing down there?" "What we've been hearing." He's not believing me. We have to relook at this. You mean, what have you seen? What do you see? What have you heard? What do you hear? It's just amazing. He does not believe me. He is not believing me. And really, it's just amazing how horrid the grammar is. You'll learn better grammar by reading what the courts have to say, and at the same time, you're filling a gap in how you treat civic duty as an American. My name is David Merlin. Thanks for tuning in to Take from Caesar. I'll see you in the next lesson.